Alrighty, it is your favorite auditor, Audit Them, the one who encourages you to audit them. Today we are going over the Open Meetings Act of Illinois, 5 ILCS 120. We have went over this in the past, I think in 2021. However, we need to go over it again. Okay. So with that being said, let's get right to it. We're probably not going to read the entire act. We're going to skim through it, but we're going to make sure we point out a lot of great parts. Tommy, hello there. Curtis, hello there. So it starts off by saying it is the public policy of the state that public bodies exist to aid in the conduct of the people's business, and that the people have a right to be informed as to the conduct of their business, in order that the people shall be informed. The General Assembly finds and declares that it is the intent of the act to ensure that the actions of public bodies be taken openly and that their deliberations be conducted openly. Gloria, what uncle? The General Assembly further declares it is the public policy of the state that its citizens shall be given advance notice of and the right to attend all meetings at which business of public body is discussed or acted upon in any way. Exceptions to the public's rights to attend exist only in the limited circumstances where the General Assembly has specifically determined that the public interest would be clearly endangered, of the personal privacy or guaranteed rights of individuals would clearly be in danger of unwarranted invasion. To implement this policy, the General Assembly declares, number one, it is the intent of the act to protect the citizens' right to know. Number two, the provisions for exceptions to the open meeting requirement shall be strictly construed against closed meetings. This act shall be known and may be cited as the Open Meetings Act. Section 102, for purposes of this act, meeting means any gathering, whether in person or by video or audio conference, telephone call, electronic means such as, without limitation, electronic mail, electronic chat, and instant messaging, or other means of an interactive communication, contemporary. Veteran, what up, though? Jack, hello there. Brooke, hello there. Scott, hello there. Meeting, any gathering, communication of majority of a quorum of that the members of the public body held for the purpose of discussing public business, or for a 5-member public body, a quorum of the member of a public body held for the purposes of discussing public business. Accordingly, for a 5-member public body, 3 members of the body constitute a quorum, and the affirmative vote of 3 members is necessary to adopt any motion. So it's three or more. Resolution or ordinance, unless a greater number is otherwise required. Public body includes all legislative, executive, administrative, or advisory bodies of the state, counties, townships, cities, villages. We know what that is. It's like a public body. Alrighty. Training. Every public FOIA officer shall receive a training yearly. We know that too. Section B, except as otherwise provided in this section, each elected or appointed member of a public body subject to this act who is in such matter of 2012, the effective date of Public Act 97504, must successfully complete the electronic training curriculum developed and administered by the Public Access Counselor. except as otherwise in section. Each elected or appointed member. Alrighty. Let's flicker. Okay. Each member successfully completing the electronic training curriculum shall file a copy of the certificate of completion with the public body. Oh, that's a good one. Completing the required training as a member of the public body satisfy the requirements of this section with regard to the member's service on a committee or subcommittee of the public body and the member's ex officio service of any other public body. The failure of one or more members of a public body to complete the training required by this section does not affect the validity of an action taken by the public body. An elected or appointed member of a public body subject to this act who successfully completed the training under this section and filed a certificate of the completion with the public body is not required to subsequently complete the training required under this section. That's very possible, Jack. That is very possible. It's gonna be like that until the people bring it to their attention that they want it revised. Section C, an elected school board member may satisfy the training requirements of this section by participating in a course of training sponsored or conducted by an organization created under Article 23 of the School Code. The course of training shall include, but not limited to, instructions in the general background of legal requirements for open meetings, the applicability of this act to public bodies. 3, the procedures and requirements regarding quorums, notice and record keeping under this act. 4, procedures and requirements for holding an open meeting and for holding a closed meeting under this act. 5, penalties and other consequences for failing to comply with this act. If an organization created under Article 23 of the School Code provides a course of training under this subsection C, it must provide a certificate of a course completion to each school board member who successfully completes the course of training. A commissioner of a drainage district may satisfy the training requirements of this section. All right, let's get past the training. Because these are all compiled. So VA, what you say you're being charged 10,000. I have no idea what you're being charged 10,000 for. What are they charging you 10,000 for? Alrighty, here we go. 122, open meetings. Openness required. All meetings of public bodies shall be open to the public unless accepted in subsection C and closed in accordance with section 2A. Closed meetings in 2A. Construction of exceptions. Hey, Brendan. You got to get more in depth, veteran. You got to get more in depth. Narrow it down for me. Let me know exactly what you're requesting. All meetings of public bodies shall be open to the public unless accepted in subsection C and closed in accordance with section 2A. Construction of exemptions. The exceptions contained in subsection C are in derogation. Let's define that. Derogation. an exemption from or relaxation of a rule of law. Alrighty, so let's get back to it. Of the requirement that the public bodies meet in open, and therefore the exceptions are to be strictly construed, extending only the subjects clearly within their scope. The exceptions authorize but do not require the holding of a closed meeting to disclose a subject included within the enumerated exception. C. Exceptions. A public body may hold closed meetings to consider the following subjects. 1. The appointment, employment, compensation, discipline, performance, or dismissal of specific employees, specific individuals who serve as independent contractors in a park, recreational, or educational setting, or specific volunteers of a public body or legal counsel for the public body, including hearing testimony on a compliance lodged against any employee, against a specific individual who serves as an independent contractor in a park, recreational, or educational setting, or a volunteer of the public body against legal counsel for the public body to determine its validity. However, a meeting to consider an increase in the compensation to a specific employee of a public body that is subject to the local government wage increased transparency act. So local government wage increased transparency act. Gonna look that up. Oh, local government wages increase transparency act. Huh. Look that up at a later time. May not be closed and shall be open to the public and posted and held in accordance with this act. Collective negotiating matters between the public body and its employees or their representatives, or deliberations concerning salary schedules for one or more classes of employees. Number 3, the selection of a person to fill a public office, as defined in this act, including a vacancy in a public office, when the public body is given power to appoint under the law or ordinance, or the discipline, performance, or removal of the occupant of a public office, when the public body is given power to remove the occupant under law or ordinance. Number 4, evidence or testimony presented in open hearing or in a closed hearing where specifically authorized by law to a quasi body as defined in this act, provided that the body prepares and makes available for public inspection a written decision setting forth its determinative the determinative reason. 4.5, evidence or testimony presented to a school board regarding denial of admission to a school events or property pursuant to section 2424 of the school code, provided that the school board prepares and makes available for public inspection a written decision setting forth its determinative reasoning. The purchase or lease of real property for the. Alrighty, anyhow, we'll fast forward here a little bit. These are exceptions here anyway. Meetings of firearm owners identification card review board. All right, here's what we could get to. Definitions. Beautiful. Is this for all 50 states? No, this is just Illinois. This is just Illinois. Definitions. For purposes of this section, employee means a person employed by a public body whose relationship with the public body constitutes an employer employee relationship under the usual common law rules, and who is not an independent contractor. Public office means a position created by or under the constitution of the laws of the state, the occupant of which is charged with the exercise of some portion of the sovereign power of the state. The term public office shall include members of the public body, but it shall not include organizational positions filled by members thereof, whether established by law or by public body itself, that exists to assist the body in the conduct of its business. Quasi adjudicative body means administrative body charged by law or by ordinance with the responsibility to conduct hearings, receive evidence or testimony, and make determinations based thereon, but does not include local electoral boards when such bodies are considering petition challenges. Quasi. Final action. No final action may be taken at a closed meeting. Final action shall be preceded by a public recital of the nature of the matter being considered and other information that will inform the public of the business being conducted. I like that one. This one is real good. Okay. Section 201, 5 ILCS 120/21. All meetings required by this act to be public shall be held at a specified times and place which are convenient and open to the public. No meeting required by this act to be public shall be held on a legal holiday unless the regular meeting day falls on that holiday. Except as otherwise provided in this act, a quorum of members of a public body must physically present at the location of an open meeting if, however, an open meeting or a public body with statewide jurisdiction too, that is the Illinois library system with jurisdiction over a specific geographic area of more than 4,500 square feet. Alrighty. Here we're going to fast forward to quorum. Section 202, public notices of all meetings, whether open or closed to the public, shall be given as follow. Every public body shall give public notice of the schedule or regular meetings at the beginning of each calendar or fiscal year. State the regular dates, times, and places of such meetings. An agenda for each regular meeting shall be posted on the principal offices of the public body and at the location where the meeting is being held at least 48 hours in advance of the holding of a meeting. Okay, I really like that one too. Let me take a screenshot. I like that one. This is basically telling you it has to be posted, prominently displayed. An agenda of regular meetings shall be posted at the principal offices of the public body and the location 48 hours in advance holding the meeting. A public body that has a website, the full-time staff of the public body maintained shall also post this on its website. Great job. So I'm going to start using language from the Open Meetings Act. The language that I'm going to use is these records have to be prominently displayed at the principal office. And then if they want to argue, well, it also says here in the OMA, a public body that has a website shall also post it on its website. All right. Anyway, we know that. It's nothing new. The agenda of any regular meetings of the governing body, of the public body, any agenda of regular meeting that is posted on a public body's website shall remain posted on the website until the regular meeting is concluded. The requirement of a regular meeting agenda shall not preclude the consideration of items not specifically set forth in the agenda. Public notice of a special meeting, except a meeting held in the event of a bona fide emergency or of any rescheduled regular meeting or of any reconvene meeting. Let me define that. Reconvene, past tense. Meeting shall be given at least 48 hours before. Alrighty, let's see section B. Public notices shall be given by posting a copy of the notice at the principal office. Alrighty, we went through all of these compiled statutes. They say the same stuff over and over. Any agenda required under this section shall be set forth the general subject matter of any resolution or ordinance that will be subject of final action at the meeting. The public body conducting a public meeting shall ensure that at least one copy of any requested notice and an agenda for the meeting is available for public review during the entire 48-hour period preceding the meeting. Posting the notice and agenda on a website that is maintained by the public body satisfies the requirement for a continuous posting under this subsection. If a notice or agenda is not continuously available for the full 48-hour period due to actions outside the control of the public body, then that lack of availability does not invalidate any meeting or action taken at a meeting. See right here, it says 3 prominent places within the governmental unit. Alrighty, let's get to the good part. 122.05, recording meetings subject to the provisions of section 8701 of the Code of Civil Procedure. Any person may record the proceedings at the meetings required to be opened by this act by tape, film, or other means. The authority holding the meeting shall prescribe reasonable rules to govern the right to make such recording. Alrighty. If a witness at a meeting required to be opened by this act, which is conducted by a commission, administrative agency, or other tribunal, refuse to testify on the grounds that may not be compelled to testify if any portion of his testimony is to broadcast or to be televised, or if motion pictures are to be taken of him while he is testifying. The authority holding the meeting shall prohibit such recording during the testimony of the witness. Nothing in this section shall be construed to extend the right to refuse to testify at any meeting not subject to the provisions of section 8701 of Civil Code. Minutes right to speak. Here's the good stuff. All public bodies shall keep written minutes of all their meetings, whether open or closed, and a verbatim record of all their closed meetings in the form of an audio or video recording. Oh, shit. Oh, that's a good one. That's a good one. So look what it says. That's going to open up us up to the FOIA Act now. And a verbatim record of all their closed meetings in the form of audio or video. Beautiful. Let me take a photo of this one. They shall include, but not limited to, the date, time, places of meeting, the members of the public body recorded as either present or absent, and whether the member were physically present by means of video or audio conference. A summary of discussion on all matters proposed, deliberated or decided on, and a record of any votes taken. A public body shall approve the minutes of its open meeting within 30 days after the meeting, or at the public body's second subsequent regular meeting, whichever is later. The minutes of meetings open to the public shall be available for public inspection within 10 days after the approval of such minutes by the public body, beginning 2006, at the time it complies with this. With the other requirements of this subsection. A public body that has a website that the full-time staff of the regular public body maintains shall post the minutes on a regular meeting of its governing body open to the public website open to the public on the public body's website 10 days after. Here's the good one. Section C. The verbatim record may be destroyed within the notification to or approval of a record commission or of the state archivist under Local Records Act or State Records Act no less than 18 months after the completion of the meeting. Wait a minute. But only after the public body approves the destruction of a particular record. So 18 months, 12 months, that's a little over a year. The public body approves minutes of the closed meetings that meet with the written minutes requirements of the subsection. Each public body shall periodically meet to review minutes. Alrighty, whatever. All that same shit over. Alrighty. Section 3A. Where the provisions of this act are not complied with, or where there is probable cause to believe that probable cause to believe that the provisions of this act will not be complied with, any person, including the state's attorney of the county in which such noncompliance may occur, may bring a civil action in the circuit court for the judicial circuit in which the alleged noncompliance has occurred or is about to occur, or in which the affected public body has its principal office prior to within 60 days of the alleged meeting. Alrighty, that's all good. Public access counselor. Well, anyway, we just flickered through it real fast. Similar language to the FOIA Act. Very similar language to the FOIA Act. I really love the section. I really love section 5 ILCS 122.06. We're going to use that. Anyhow, guys, thank you for tuning in. We'll probably be on a little later. Be on the lookout. I did a few days ago visit DuPage County building, and they have several departments with separate FOIA officers. So that one was an hour and 40 minutes long. I'm going to chop that video up into like 5 parts. Part 1 of 5, part 2 of 5, part 3 of 5. I'm going to release them back to back. Probably this week I'm going to release 1 of 7 or 1 of 5. So make sure you be on the lookout for all what's coming. And other than that, guys, thanks for tuning in. The one who encourages you to audit them.